Significantly, the Electoral Act 2022, which came into force after this deregistration, retained and reinforced these deregistration provisions in Section 94, demonstrating legislative intent to maintain strict criteria for political party viability. However, something profoundly shocking and deeply suspicious occurred during the 2020 deregistration exercise. While INEC correctly identified APP as one of the parties that had failed to meet constitutional requirements, the Commission made a false and unsubstantiated claim that APP had obtained an interim court order restraining INEC from deregistering it, and therefore had to be temporarily exempted from the deregistration list. This claim was and remains false. There was no suit filed by APP in any court of competent jurisdiction in Nigeria. No suit number had been produced. No originating summons exist in any court registry. No motion for restraining order was filed, and consequently, no restraining order was ever granted by any court. This was simply a fabrication, a hatchet job executed by some corrupt officials within INEC working in criminality and criminal conspiracy with the owners of APP. To know those behind this heinous crime, we have procured and shall hand over to you the certified true copies of the Constitution of APP and its manifesto as submitted to INEC before its registration in 2027. The question that demands an answer is this: why would INEC, a constitutionally established institution charged with ensuring electoral integrity, manufacture a non-existent court order to shield a failed political party from lawful deregistration? Why would that happen? Even if we were to momentarily entertain INEC's insulting claim that an interim order existed in February 2020, which factually did not exist, the principle that such an order will remain in force for nearly 6 years represents the biggest fraud in Nigerian legal history. Under Order 2019, an interim injunction granted ex parte shall lapse after 14 days unless the respondent is served and the matter is heard inter partes. Under Order 43, 3 of the same rules, every application for interlocutory injunction must be supported by an affidavit and must be removed on notice to the other party. The Court of Appeal rules and Supreme Court rules contain similar provisions, ensuring that interim orders are temporary measures, not permanent restraints. No interim order in Nigerian legal jurisprudence can survive for 6 years without being renewed, extended, or converted to a substantive order after full hearing. The very concept of an interim order presupposes temporariness. It is meant to preserve the